Welcome to the Missouri Freedom Initiative. Today is Tuesday, February 8th, 2022. Hey, gang, the Supreme Court hearings were yesterday in Missouri for the Second Amendment Preservation Act, in which the lawsuit for St. Louis County, and Jackson County, along with the Department of Justice against the state of Missouri for our new law, the Second Amendment Preservation Act, commenced. Well, I'm going to tell you a little bit about it. I'm going to read this article. I'll link everything down below, by the way. And then I'm going to end this with a 30-minute audio recording of what happened in the court. Cameras and recording devices obviously are not allowed in the Supreme Court, so therefore I could not record it for you or videotape it for you. That was strictly prohibited. So was actually going in there without a mask, by the way. That's another story. But I did want to share this with you and give you my impressions of what happened. So let me start by reading the article. The Missouri Supreme Court heard case against the Second Amendment Preservation Act. The Missouri Supreme Court heard arguments regarding the constitutionality of a law proponents refer to as the Second Amendment Preservation Act on Monday. The law prevents several gun control measures from being enforced in the state. Law enforcement agencies in St. Louis County, and Jackson County have asked the courts to block the law. They argue, among other things, that the new law prevents them from cooperating fully with federal law enforcement. Jeffrey Sandberg, U.S. Attorney, he came from the Department of Justice, by the way, I saw him yesterday, says state and local law enforcement agencies fear incurring $50,000 penalties for created for violating the law. That's the point of the law. There's teeth in our law. There's ramifications for law enforcement for breaking the law. That's exactly what he's talking about. And this is why Missouri is the only state that has SAPA that's being attacked by the Department of Justice, too. All the other 13 states that have SAPA law don't have teeth like ours. There's no ramifications for law enforcement breaking the law. Okay, so Jeffrey Sandberg says, quote, "You have the Missouri State Highway Patrolman who has stopped the federal fugitive who was passing through the state of Missouri, has no connection to the state, but lets the person go at a traffic stop, even though he knows he's a federal fugitive because he fears potential consequences to the agency," says Sandberg. John Sauer, Solicitor General, and he, basically was representing the Attorney General's office for the state of Missouri, asked the court to uphold the lower court's verdict, which rejected the local government's arguments. He says the law doesn't explicitly prevent Missouri law enforcement from participating in federal resources such as federal background check databases in the National Integrated Ballistics Information Network, which is true, by the way. We've covered that in podcasts in weeks and months gone by. He said they didn't seek clarification on those points when the case was previously heard in a lower court, and that's in Cole County Court. Justice Green was presiding. No one went into the trial court, he said, "Hey, please tell us whether this is covered by the statute so we can give clarity to law enforcement," said Sauer. The state also argued that the Supreme Court is the wrong venue for this case, and that several other pending lawsuits could resolve these issues. The court will rule in the coming weeks. Okay, so that's what we would call a summary by the media. Let me tell you what it was like being in the courtroom. I came out of there feeling pretty good because, for no other good reason than the attorney that represented the plaintiffs, which would be St. Louis City, St. Louis County, and Jackson County, was basically chastised by three of the justices for various reasons, saying, this stuff should have been done in the lower court. This isn't the right venue for what you're bringing to us right now. Now, it was the Department of Justice who brought up the constitutionality of the Second Amendment Preservation Act as it applies to anti-commandeering doctrine in the 10th Amendment. So that's what we were expecting. The guy from St. Louis, or representing St. Louis County and Jackson County and St. Louis City, was talking about procedural problems with police departments having to deal with the new law. So, of course, the court said, we're not going to help you with procedure with police departments. That's not what this is about here. So he was rightly chastised. However, it is important to note that four of the justices never spoke. So while I'm telling you that three of the justices kind of, chastise, the attorney, the plaintiff, a little bit in the court, we didn't hear from four. So that's something that, we have to think about. But at any rate, I did feel very positive coming out of this that, basically it is going our way. And by our way, I mean the way of the Constitution. So I do realize that the Missouri Supreme Court has been political in the past. They may end up being political on this. We don't know. But we're going to have to wait. As the article said, they're going to reach a decision on this. And we'll report on that when they do. I did a lot of other things while I was up in Jeff City, and I don't want to report on them in this podcast, but one of them will end up probably being an announcement that'll be made within the next 3 weeks. It's a big one, too. So I had other things to do up there. And I want to report also that KC Rich, our very own KC Rich, also came up to Jeff City as well. And so he was able to witness some of these events. He did not make it into the main courtroom. That's a long story having to do with masking. But he did make it into the overflow room, so he was able to see through the CC television, basically what was going on in the court. Aaron Dorr and Ron Calzone were also there in the courtroom to hear the proceedings. So those are the only other two people that I knew personally that were there, apart from, of course, Casey Rich. They had the chairs spaced for social distancing. We could have fit 4 times more people in that courtroom. But since they're all about masking and social distancing, in the Supreme Court, basically, I think there was about 35 people maybe in that courtroom. So that's about as many as they could fit in there because of the social distancing requirement. So that pretty much covers everything that happened yesterday. And like I said, more videos are coming soon. And the next 30 minutes is the audio that comes from the Supreme Court. Now, remember, I told you I couldn't do any recordings in the Supreme Court. In fact, if you go to the Supreme Court website, they actually have information about cameras in the courts and recording in the courts, which you can't do unless you basically set that up in advance with the court. I don't have journalistic credentials, so there was nothing I could do in that regard. However, the reason why I provide sometimes boring snippets from proceedings that happen in the Missouri legislature, or in this case in the Supreme Court, is so that it is on record. We have other states that are trying to get SAPA with teeth right now, and we want to give them a fighting chance, let them know everything we're up against, since we have the law and it's being challenged by the Department of Justice right now. So those of you who want to listen to it, great. Those of you who don't, great. But it'll always be here in this video and on our other platforms for others to be able to reference as they go through this process in their states, because we don't want to be the only ones in the United States with this law. Okay, gang, that's all I have for you for now. More videos coming very soon. We'll have another live stream on Sunday night. And for now, I just want to say thank you very much for hanging with us. Thank you for having an interest in what we're doing here with people's Second Amendment rights, the right to self-defense, a natural right, God's law, if you will, in the state of Missouri. We're fighting very hard for it here. And there's a lot of people involved in the fight. So don't think for a second it's just me. There's a lot of people involved in this fight. So thank you for hanging with us. May God bless each and every one of you and all of your families. Take care, gang.
Chief Justice, may it please the court, when I was rereading the state's brief in this case last night, it struck me that the Second Amendment Preservation Act is misnamed. It should be the Separation of Powers Destruction Act. House Bill 85 is an amazing departure from conventional constitutional legislation. It is a plain effort by the General Assembly to declare laws invalid and proscribe their enforcement. And the separation of powers issue is just one of multiple constitutional defects in the legislation. I almost said multifarious, but Mr. Sauer will be ragging me with that word shortly. But I have to say that if I did stumble into a multifarious point, it was because I was attempting to concisely explain all of the specific state constitutional defects in the legislation. And if I erred in combining that into one point, I would urge this court to follow its long line of precedent in which this court recognizes the purpose of the rules, which is to achieve as Rule 41 says, the prompt, speedy, and inexpensive disposition of cases on the merits. So I would say that the separation of powers problem looms very large in this case. The plain language of the statute says that a range of ill-defined, indeed undefined, federal laws, regulations, orders infringe the Second Amendment and shall not be enforced in Missouri. And the problem is that the plaintiffs, law enforcement employees, regularly participate with the federal government in attempting to suppress illegal firearms and other illegal criminal activity with which firearms are inevitably associated. And the way House Bill 85 is worded, the law enforcement community is disabled, if the statute stands, is disabled from using the National Integrated Ballistics Tracking System and the firearms identification tracking systems, all of which are used by the federal government or spawned by the federal government, and all of which contribute significantly to the suppression of violent crime in this state and in particular in the local political subdivisions that we represent. And so I submit that this is a separation of powers problem, and without separation of powers, we do not have a constitutional structure that emanated from the founders. We have the High Court of Parliament sitting across the street instead of the General Assembly. And I advert to again, the plain language of 1.420 declares that federal regulations and laws infringe the Second Amendment. And the Attorney General's brief uses the word disfavor. The statute does more than disfavor federal laws. It forbids their enforcement. And compounding all of this, and I confess that the point could have been more meticulously presented in the court below and in our opening brief, but we have what is really an unintelligible statute. And I think that any fair reading of the statute leaves a person of ordinary understanding completely at sea as to what federal laws and regulations are forbidden to be enforced. And then to compound the constitutional problems, the statute then trenches upon the authority of constitutional charter cities and counties to prescribe the qualifications and the powers and duties of their law enforcement employees. And I submit that this is not, and I think my good friend Dave Rowland claims the city wants to secede from Missouri. No, the city wants to enforce the Missouri Constitution. And we think that the Missouri Constitution can and should be enforced in this regard, because the city is being forbidden to maintain on its payroll a law enforcement officer who has participated in some fashion in enforcing some federal laws that somebody thinks infringe the Second Amendment. And I think that the circuit court unfortunately elected to treat our claim as something that could be dealt with in another way. And
so, Counselor, excuse me for interrupting you, and I know your time, you're going to divide it up with your co-counsel there, but would you discuss, your opponent argues that declaratory judgment was not proper here because there are alternative remedies. Can you discuss that, please?
Well, that's exactly what I was about to discuss. You know, I think that the Alpert case very clearly says that a party that is subject to an unconstitutional law does not have to wait to be sued or subjected to a multiplicity of lawsuits, nor does that party have to violate the law before that party can bring an action under the declaratory judgment statute. And the statute 527.020 clearly authorizes an action to get a declaration of rights and obligations under a statute, and it also uses the word validity. And I submit that the lawsuits that have been brought by federal prisoners against the city and now the county also do not provide an adequate remedy. We are parties to ongoing agreements with the federal government aimed at enforcing gun laws, and those laws include federal laws, and our officers are deputized as federal officers to participate in these task forces. We don't know how to address this going forward, and these lawsuits by federal prisoners, in addition to being not cognizable because the federal prisoners have no, the conduct they're attacking occurred prior to the effective date of the statute, but the point is we are at risk of multiple potentially conflicting outcomes in circuit courts all over the place. Sure, there are sound jurisprudential reasons at times for the judiciary to avoid constitutional issues. Sometimes I practice that myself. I'm not an apostle of judicial activism, as I think most of you know, but I think that there is no choice in this regard but to face the central problem with this statute, which is the overreaching by the General Assembly, flying in the face of Alpert and Redmond v. Parson in particular, except this time the General Assembly wants to usurp the authority of the judiciary.
Even if you're correct, though, Mr. Durkert, the problem here, though, isn't it a problem that you didn't request this relief yet at the trial court level? So all that was ruled upon was the state's motion to dismiss, because their argument is that there were other adequate remedies at law that could have been pursued. And so what's the remedy? If you were correct, what is the remedy here? Isn't the remedy that we just send it back to the trial court to deal with all these merit-based issues that has yet to be raised at the trial court?
Well, we did ask for the relief that we're asking under 8414 from this court, which is the declaration of the invalidity of the statute in our petition. We filed a motion for preliminary injunction, but I would point out in another case, I don't want to say there's a long list of them, but another case in which I was reversed, where I dismissed the declaratory judgment action, and this court proceeded to declare the validity of the ordinance, which was a penal ordinance, in question at that time, because I think the law is clear that on a motion to dismiss or for judgment on the pleadings in a declaratory judgment action, the court can, if there are no facts in dispute, and there are none here, the court can proceed to the merits. And so I submit that by asking for the preliminary injunction and by opposing the motion for judgment on the pleadings, we did request the relief that we seek here. And I would like to yield my time to the Justice Department to discuss in more detail the Supremacy Clause issue, which I think we have clearly preserved and which we in the United States are in sync on.
Good afternoon. May it please the Court, Jeff Sandberg for the United States. I want to thank the Court very much for the opportunity to be here this afternoon. In just a couple minutes, I'd like to say why I'm here, why we urge the Court not only to reverse the dismissal, but to reach the merits, as Your Honor just asked about, and to make one quick point about the merits. The federal government cares about this case because this law has posed substantial threats to public safety. Because of HB 85, it has become harder for us to investigate all manner of crime, including violent crime, in this state. Some state and local law enforcement agencies are no longer inputting ballistics data into national databases. The State Fusion Center has stopped working with us. The State Crime Lab has stopped running tests. That all makes it harder to investigate crime at the front end.
And that may be, but if that's, but isn't that up to the General Assembly that they can decide that the state of Missouri doesn't want to participate in these type of programs, that their state officers aren't going to do that? So what does that have to do with the Supremacy Clause?
Well, that's the point on the merits that I want to make, which is this is not a case about whether the federal government can force a state to devote resources to enforcing federal law. We recognize, we agree, the federal government cannot do that. That is not proper. But we're here considering a statute. We look to its plain and ordinary meaning. HB 85 doesn't state any decision to focus resources on state enforcement rather than federal enforcement. What the law does is it declares several generally defined categories of federal law to be unconstitutional, notwithstanding federal precedent to the contrary, and then imposes a bunch of follow-on duties.
Don't law enforcement officials make constitutional judgments every day, whether or not a search is unreasonable or not, whether or not a statute's violative or not? Don't they have to make constitutional decisions in their everyday work?
Yes, and law enforcement officers in this state are mindful.
Right, and so what if they agree with you and just ignore the statute?
Well, our experience has been that they have not ignored, many agencies have not ignored the statute. The Missouri State Highway Patrol, which operates the
some have ignored the statute and continue to cooperate.
we are reaching out our hand in cooperation to state, local agencies that will work with us because we want to work together to solve the problem of violent crime in the state. But we are running into problems where there are people who want to cooperate with us, but they are mindful, they're making judgments on the spot about what might potentially put their agency's budget at risk. They are fearing $50,000 penalties for cooperating. So because of that, you have Missouri State Highway Patrolmen who has stopped a federal fugitive who's just passing through Missouri, has no connection to the state, but lets that person go at a traffic stop even though he knows he's a federal fugitive because he fears the potential consequences to his agency of that traffic stop. And that's what we're dealing with here. And we're concerned. I mean, the decision about what charges to bring, whether it's a federal charge or a state charge, is made further along in the case. Sometimes you're investigating a crime and you're just trying to find the perpetrator. You're trying to find out what's going on. And we are seeing problems at the front end. You know, evidence doesn't necessarily carry a federal or state tag attached to it. And so that's why we think it's appropriate for this court to exercise its sound discretion to move the ball as far forward as it can. And maybe it's not an entry of judgment in favor of the appellants if you think that that hasn't been raised, but it certainly would be directing an entry of the preliminary injunction on remand. I see my time has expired. I'd be happy to answer any other questions. But
thank you. We'll hear from you on rebuttal. Great.
Mr. Chief Justice, and may it please the Court, John Sauer on behalf of the state respondents. I want to start by addressing the question of whether or not there's an adequate remedy at law here. Obviously, that's the ground on which the trial court rested, and I think that that was really a bulletproof, unshakable ground and for the trial court to rule that way. And the reason is, unlike all the cases that they rely on, here at the time this lawsuit was filed, this DJ action was filed, and all the way through since then, there already were pending cases, already filed civil cases against these plaintiffs in which they have the opportunity, not only have the opportunity, they already have raised the only claim they've raised here, which is the facial invalidity of the statute.
What's the nature of those other lawsuits?
They're they're under 1.460, so they're individuals who have been prosecuted or arrested and stuff like that. They're brought by, Judge Doker has described them as federal prisoners. I don't know if they're all prisoners, but they're all individuals who have asserted claims arising under 1.460, essentially saying, hey, your officers violated 1.450. And in at least 3 of those cases, 1 in answer in affirmative defenses and in 2 in motions to dismiss, the plaintiffs here, as defendants there, have raised all the constitutional challenges to the facial validity of the statute that they want to raise in the DJ action. So you're in Cole County, you have 5 cases pending in Cole County where they can and have raised the very same constitutional arguments that they're raising in their separate offensive DJ action in Cole County. If that's not an adequate remedy at law, nothing is. And in fact,
so the brief says 2 cases. You said 5 cases?
Well, I believe that we've identified 3 where they've actually already raised it, but I believe there's at least 2 more where the case numbers have been cited in the briefs where they can raise it. I went to CaseNet this morning and I looked up 3 of these case numbers and found for answer and affirmative defenses in 1 and motion to dismiss in the other 2 where they actually have already raised the constitutional validity of the statute. And they conceded at the oral argument in front of Judge Green that 2 of those cases were already pending before they ever filed the declaratory judgment action. Well, that serves to distinguish all the cases they rely on, including Alpert. Alpert, the majority opinion in Alpert talks about how you don't have to violate the statute yet, but it was emphasized in that case that the person there who was this elderly man with cancer who wanted to get some World War II era guns, there was no criminal action pending against him yet. There was nothing pending already where he could already raise it. This is a totally different situation where something's already pending, not just 1, not just 2, but 3, 4, 5 different lawsuits. And as far as I can tell, they're all in the same court. They're all in Cole County.
Has the Attorney General entered appearance in all or any of those cases?
We have not done so yet, but I would note that we haven't received the statutorily required notice from any of these plaintiffs/defendants.
You would concede you do know about them.
We do know about them now, and we actually intend to intervene in those, and we'll defend the validity of the statute, raising probably many of the same arguments that have been raised in this court. The question here, though, is whether the court should disregard its really well-established jurisprudence on the requirements for a declaratory judgment action. I'd emphasize with respect to Alpert that there are 4 elements to the declaratory judgment test, essentially, claim. The third one is whether or not the controversy is ripe, and that was really the focus of the majority opinion in Alpert. The fourth one is a separate one, is in addition to ripeness, is whether or not there's an inadequate remedy at law. That's the 4th element. And so essentially Alpert really was addressing, when it was talking about defending multiplicity of suits and so forth, it was addressing a situation of whether or not it's ripe, whether or not you have to go out and violate the statute first. That is a distinct question as to whether or not you have an adequate remedy at law when you have an already pending lawsuit in which you have which you can and have raised these very same arguments as affirmative defenses.
On these 5 cases, though, aren't they dealing with violations? If they were violations of these new statutes, they would have been, the alleged violations would have occurred before the enactment of this statute. Is that right? So there would have to be a finding of retroactive application of this bill.
The United States has argued that. The plaintiffs haven't argued it. The United States argued that in their brief. I haven't verified that. Frankly, I haven't gone through the docket in each one of those to say, and I don't think it makes any difference for at least 2 reasons.
But then there wouldn't be a case. But if we would have to show retroactivity, then there may be not any cases to even deal with this that are currently on file.
The way I would put it is, if that's the case, in those cases, they can also raise retroactivity as an affirmative defense. So they have multiple affirmative defenses in those cases. There is no case, there couldn't possibly be a case that says, for it to be an adequate remedy at law, it's the only defense you can raise in that case. Take, for example, the drunk driver case, which is Schaefer against Koster, that we rely heavily on, and I think it just absolutely controls here. In that case, the sort of repeat offender drunk drivers were already being criminally prosecuted, and they file a DJ action in Cole County to try and invalidate the statute that gives the enhanced penalties. Those drunk drivers, for all we know, probably had all kinds of other defenses to those criminal prosecutions, like, hey, it wasn't me, somebody else was driving the car, or, you know, my blood alcohol content wasn't above the threshold level, and so forth. This court never said, well, for it to be an adequate remedy, it has to be the only defense that you can raise in the already pending action. I mean, I'm not aware of any authority for that. So if they say, well, those aren't adequate, what they're really saying is we want clarity now. Right? They're saying they're saying the adequate remedy at law isn't fast enough. Right? That's really the argument. It's really a policy argument that's being made. I would say 2 things to that. First of all, it's an adequate remedy at law. It's not an adequate remedy in equity. Right? So in other words, their argument is, well, gee, we really want to get a preliminary injunction right now. That's the last thing you heard from the United States in this case. But there's no authority that supports the notion that it's got to be fast enough. You've got to be able to get equitable relief. It's got to be an adequate remedy at law where you have the opportunity to actually raise this. That's what all the case law contemplates, and that's exactly what we have in this case.
Mr. Sauer, the plaintiffs cite in their brief some cases from our court that talk about even if there's not, or even if there's an alternate remedy at law available, I'll read from their brief. The existence of an alternative remedy does not categorically preclude a court from entertaining a declaratory action if consideration of public policy, interest, and efficiency, convenience, and good faith of the plaintiff favor prompt decision of the dispute through declaratory judgment. Could you respond to that?
I don't see those cases as standing for that proposition at all. I think, frankly, it's I would say, charitably an aggressive reading of those cases. If there is an adequate remedy at law, that is an element of a declaratory judgment action. This court powerfully reemphasized that actually in May of 2020 in the first NAACP case, which said, look, these are the 4 things. These are the elements of a declaratory judgment claim. And number 4 is there has to be inadequate remedy at law. And I would also emphasize that it is their burden to come forward and establish those elements to plead and prove them. They really didn't even plead adequate or inadequate remedy at law. The petition only contains just a recital that there's no adequate remedy at law, and then they conceded that we're being sued. In fact, their argument wasn't that we have no adequate remedy at law because we're not facing any lawsuit. It was the opposite. They're saying we're facing a cascade of lawsuits. That was the phrase used in the trial court. We're facing a cascade of lawsuits, and therefore we need an equitable remedy now. But the standard isn't an equitable remedy. That's that argument. They're saying, hey, you know, for equitable reasons, let us reach this. The standard is there an adequate remedy at law? And of course, if they're not facing a cascade of lawsuits, as the Chief Justice's dissent in Albert pointed out, that's going to raise troubling problems about ripeness as well. So this is a case where I think it's just squarely within the 4 corners. Schaefer against Koster, and again, Redmond against Parson reemphasized this. The court in Redmond said, look, Mr. Redmond, we agree that often you do have an adequate remedy at law, citing Schaefer against Koster, citing the SLAH case. I don't know if people say SLA or SLAH. And they said, but look, Mr. Redmond has no other way to raise this claim at all. Here it's the exact opposite. We got 5 pending lawsuits, or 4 or 5, I'm not sure how many, at least 3 where they've already raised these very claims. If this is not an adequate remedy at law, that phrase means nothing. It's just been excised from the test, and that's a really long-standing piece of this court's jurisprudence, and the court should adhere to it. I urge the court to do so in this particular case. In addition to that, I'd point out that there are also remedies that they could have sought but did not seek in the trial court that might make this case look very different. Because a lot of the concerns that they're raising, the practical concerns, have to do with, hey, we're not sure if we can participate in these various federal state cooperative programs. But they didn't add claims to their petition in the trial court saying, please give us a declaratory declaratory judgment whether or not the NIBIN program is covered by this, or National Instant Background Checks, or OSADEF, the various federal state cooperative programs that they say are being hampered by this particular thing. No one went into the trial court and said, hey, please tell us whether this is covered by the statute so we can give clarity to the law enforcement officers around it.
Is it true they also didn't seek an as-applied challenge?
Absolutely right. Absolutely right, Your Honor. They didn't say, hey, it's unconstitutional as applied here. They went only whole hog.
So their claim is that there's no reading of the statute that could be constitutional under any set of circumstances.
Yes, it is only a facial challenge. In all of the 5 different constitutional challenges they've raised, they're only seeking facial invalidity. That's exactly
And other than the temporary injunction, what affirmative relief did they seek at the trial court?
Only temporary injunction. So again, turning to that question again, they did not file a cross motion for judgment on the pleadings. They did not file cross motions for summary judgment. All these cases under Rule 84.14 that they rely on, including the Nikolai case that I didn't know Judge Durker was the trial judge for that. But the Nikolai case is the case where the guy's got 19 cats. And it's a question of whether or not he's running a cat kennel in his house. And what this court's opinion said is when the parties came here, they stipulated and requested that this court, it's not clear whether cross motions were filed in that case, which is my understanding in every other case where the court says, hey, we're going to enter the judgment that the trial court should have entered. Well, there's no question that Judge Green should not have entered a judgment in their favor. There was never a motion for final judgment filed by them. They filed a PI motion. We filed, our motion was for judgment on the pleadings, emphasizing the ground in which the trial court ruled. I think we also discussed the merits in that, but we emphasized heavily the ground in which the trial court ruled, which is there's an adequate remedy at law here, and that's how it resolved. It'd be extraordinary to do what they're asking the court to do. I'm not aware of any case that supports it, where they would come in and say, hey, we never asked the trial court for judgment, but please, reverse the judgment in the state's favor and enter judgment in our favor, a judgment that was never requested in the trial court. The only thing asked for was a preliminary injunction motion. And so that.
But the potential issue, though, here is that if we don't accept the trial court and your argument with respect to the adequate remedy of the law, and we go forward, don't we have to reach the merits in order to determine, because as you argue, that if there's any other basis for affirming the lower court, then we need to explore those issues?
I think the court would have the option there. My belief is exactly what you said. The only way the court can reach the merits is as an alternative basis for affirming the judgment in our favor, because we're the only one who raised it, and a motion for final judgment below. But the court could also say, you know what, we're reversing it. I think the court certainly has the discretion to say, and this is what we've suggested in our response to their 5th point relied on, is, look, if we happen to disagree on the question of adequate remedy at law, the case can be sent back for the trial court to look at the constitutional issues in the first instance. And we cited actually the U.S. Supreme Court's case law on this that describes the Supreme Court, and obviously it applies to this court just as well, as a court of review, not a court of first view. What they're really saying is please short-circuit everything, short-circuit this adequate remedy of law, short-circuit the fact that we never asked the trial court for final judgment, and kind of treat this court as a court of first view. That's not the ordinary role for this court, for the U.S. Supreme Court, or really any court of appeals. So it's just dealing with all these threshold issues, they're asking things that are extraordinary departures from this court's jurisprudence again and again and again. And so I don't think the court does need to reach the merits. The court, I think, has the option of affirming the judgment on the alternative ground that the statute is constitutional for the reasons we discussed at some length in our brief. But as we suggest in our response to point relied on 5, kind of the natural way to go forward would be just to remand it to the trial court to consider the constitutional issues in the first instance. Having addressed all those threshold issues, I think I'd be inclined to rest on my briefs and all the various merits issues we've discussed. We have briefed them extensively, unless the court has particular questions about any of those or any other matter.
Thank you.
Thank you, Your Honor. We ask for the court to affirm. Thank you.
Thank you. We'll hear from appellants in rebuttal.
Please, the court. The problem with Mr. Sauer's argument is that raising these issues as an affirmative defense is going to put us in the same position we're in now, except at risk of multiple inconsistent rulings or other rulings that will not address the merits. Mr. Sauer talks about us pleading the validity of certain agreements that we already have. And I know what his response would have been if we had done that. We're asking for an advisory opinion about these agreements. You have to wait until you've violated the law or somebody sues you. And there is a substantial risk here of civil penalties of $50,000 if we keep police officers on the payroll who have violated these laws that are unconstitutional, except we don't know which ones they are. And we are also subject to $50,000 penalty, excuse me, for any conduct that violates these disfavored statutes.
Counselor, what about the problem that you sought no affirmative relief in the trial court other than a temporary injunction? So, for example, you make a facial challenge, but there's no opportunity for a trial court to determine whether there's any set of circumstances or any interpretation of the statute that could be made constitutional. And then that would put you into an as-applied challenge, possibly, one which you haven't pled, as I understand.
Your Honor, I respectfully point out that we did plead in the petition for a permanent injunction and for a declaratory judgment of invalidity. Yes, we are attacking.
But those things weren't heard.
Well, the motion for preliminary injunction was heard, and in dismissing the entire case, the circuit judge implicitly denied our request for injunctive relief. I mean, we're stuck.
Did he dismiss the case, or did he enter a judgment on the pleadings?
Well, he entered a judgment, but in the course of the language in the judgment, he said that that our claim is dismissed, our injunctive claim is dismissed as moot, and the preliminary injunction is denied as moot. And, we asked for the preliminary injunction, but, I would emphasize in the Gurley case, unlike in Nikolai, there was no agreement that the court could go ahead and proceed to the merits. The court went ahead and did it anyway. And the court did so because of the pressing need to resolve the issues before it. And I would say that, contrary to Mr. Sauer's view, Alpert clearly supports the position that this is an appropriate avenue for declaratory relief, and we need prospective relief. We need forward-looking relief. The drunk driving case,
well, what does our record on review consist of then?
I'm sorry, Your Honor?
What does our record on review consist of then? Where there's just one party who makes a motion for judgment on the pleadings, and the other party doesn't seek any affirmative relief other than a temporary injunction?
I believe that the entire record is properly before this court because both motions were intertwined factually and legally.
Well, then would that make it a motion for summary judgment?
Well,
which the trial court clearly didn't think it was doing.
It does not make it a motion for summary judgment, but I believe by analogy to the summary judgment cases, the fact that the trial court accepted the state's motion for judgment on the pleadings and dismissed our injunctive claim, as the ACLU case that's cited in our brief indicates, when that disposition is a final judgment, I mean, there's no dispute that we have a final judgment here. And our position is, by analogy to the summary judgment cases, the interconnection of the issues warrants this court's plenary review because there are no facts in dispute.
Based on what record?
I beg your pardon?
Based on what record?
Based on the entire record below, both because the preliminary injunction was argued at the same time as the motion for judgment on the pleadings, but if I may trespass a moment longer, even if we ignore the record on the preliminary injunction, the motion for judgment on the pleadings admitted the material factual allegations of our petition, which lay out in substance the threat that this statute poses to law enforcement and the risks that we are facing of multiple lawsuits. And in the final analysis, the Declaratory Judgment Act has always been construed in light of equitable principles. So we respectfully request that the court reverse the circuit court and enter judgment for the city, or at the minimum, remand with directions to grant a preliminary injunction. Thank you.
Thank you. The case is submitted.